Today we are going to be talking about a case called Coons v. Platkin. Now this is an important case, all right? We're just at the point right now where we're dealing with what we call a preliminary injunction. I'm going to give you some procedural things of what's taking place, how this preliminary injunction's been ruled on, and the kind of implications that it's going to have for CCWs across the country. More specifically in my home state of California, where we have similar legislation that's pending in the state legislature right now. So a little bit of a procedural thing so that you kind of understand where we're at. After the Bruin decision, a number of states decided, especially states that were antagonistic to the idea of issuing concealed carry permits, they decided that since they had no choice but to issue permits, they were going to create regulations that effectively prevented you from going outside of your home with a firearm. Sure, they give you a permit, but you can't actually exercise the right because they've essentially created all these statutory locations where you're not allowed to have a firearm, or alternatively, they would create statutory mandates that would be very, very difficult, if not impossible, for you to overcome to be able to carry a firearm. Now, in my home state of California, we tried this with something called SB 918. This was a legislative attempt to essentially create all of California as a sensitive location where you cannot possess firearms, even with a CCW. That failed in the state legislature, and they're attempting to do it again with another version referred to as SB 2, and we'll have to see how that happens. New Jersey, the case that we're actually going to be talking about today, they moved at a faster rate of speed, and they actually got their Chapter 131 passed by the legislature and signed into law by the governor. This was immediately followed by a lawsuit by a number of different plaintiffs and an immediate request for a preliminary injunction so that this law would not take effect while the parties litigated the constitutionality of Chapter 131. So that's what we're actually discussing right now. The parties moved for a preliminary injunction, and the judge recently issued her opinion. The judge is Renee Bum, and she does a really, really, really extensive analysis of the Second Amendment. The opinion itself is, I don't know, it's about 200 and some odd pages long. It really goes into a granular analysis using the Bruin test to determine whether or not a particular aspect is in fact constitutional. Now, if you've seen my videos before, we talk a lot about preliminary injunctions because this is sort of the thing that's happening right now as we're contesting a lot of these gun control laws that are, candidly unconstitutional. One of the first things that we ask is that these laws get enjoined from being enforced while we go through the laborious aspect of actually litigating it. Whenever we, essentially make the argument for a preliminary injunction, one of the threshold questions is, number one, whether or not we are likely to prevail at the actual trial. That's something that the judge has to determine. So they essentially have to do sort of a constitutional analysis, and whether or not our rights are going to be irreparably harmed if, in fact, the injunction is not issued. Now, there's some other stuff that sometimes goes into the mix as well, specifically something we call standing. We're not going to get into that in any great detail. But the judge goes through, like I said, a very, very exhaustive analysis on each part of this Chapter 131 to determine whether or not the plaintiffs are likely to prevail at trial. Now, there are a number of aspects of Chapter 131, and that's one of the reasons why this opinion is so long. She goes through and essentially analyzes every single challenged component. Now, I'm going to tell you, it is a good decision. It's not what I would say a great decision, okay? So one of the things that it starts off with is a concept of whether or not an individual should be issued a permit to begin with. And the argument is that there has to be some form of a determination by interviewing other people that the applicant for a CCW knows to determine whether or not this person is what we refer to as a virtuous person. And she goes through this very interesting analysis where she essentially says, no, there is not supposed to be a virtue test in deciding whether or not you're going to be able to exercise a specifically enumerated right. Nothing like that existed at the time of the ratification. So when it comes to that, she says, I'm not going to issue a preliminary injunction on this. We still need a greater amount of information. But she definitely telegraphs that she's probably going to be overruling that when the final outcome of the decision comes to place. There is a challenge made that the law in its entirety is what we call void for vagueness, essentially saying that there's so much ambiguity in the underlying legislation that nobody could reasonably be expected to be able to follow it. Same type of thing. She sort of punts on that. She says, no, I think there's a certain degree of specificity to it, so we're not going to enjoin the entirety of the law for being void for vagueness. Then she gets into character references, where this again goes back to the idea of being a virtuous person. And the way the law is written out, you have to supply, as you apply for a CCW in New Jersey, you have to supply, I think it's 5 individuals that would essentially testify in your behalf that you are this mysterious good person. And then it requires that these individuals actually be formally interviewed by a law enforcement agency. The state would actually get involved in talking to these individuals one-on-one. That one she seems to have a problem with. She says that might actually be unconstitutional. Apart from a Bruin analysis, it might be a degree of compelled speech. So she does issue a preliminary injunction on that aspect of it.
Quick pause here to remind you that we have a super secret giveaway going on right now. It's absolutely free. Just click the link in the description down below to find out what you could win. Now back to the video.
For fees associated with getting a CCW, fees going over $200, she says, no, these are going to be constitutionally permissible. The Bruin decision does not get into a degree of specificity of when a fee becomes unreasonable, but she finds that in this particular context, a fee of about $275 is in fact reasonable. Insurance. Now, this was an interesting one. One of the requirements in Chapter 131 is that an individual must have a form of liability insurance to carry a gun outside of their home, specifically $300,000 worth of liability insurance. And this one, she says, is in fact unconstitutional. That, requiring somebody to buy insurance in order to exercise a specifically enumerated right is contrary to the Constitution. She actually goes through a far more exhaustive analysis than that, but I don't want to take up a 4-hour video here. Suffice to say, it's enjoined. Sensitive locations. So this, we start getting into specific locations where an individual cannot bear arms. And for every single location, she goes through a Bruin analysis. This is one of those areas where I mentioned earlier, I take issue with a couple of the places, okay, that she essentially does not enjoin from being put into force. But let's go through them one by one. She says that public gatherings are not going to be construed as a sensitive location. She also enjoins the concept of what we call the default rule. Now, California is trying to do something very similar, essentially saying, hey, if you have a business and you want people to be able to come in with their firearms, you have to specifically state that they are welcome to come into your business with a firearm. If you're silent on it, it will be presumed that you don't want them coming into your business with a firearm, all right? This is sometimes referred to as the default rule, and she says this is absolutely unconstitutional. When you open up your business for public use, or when you have private property that you are inviting the public on, it is generally assumed that you can come in pretty much any condition you want with whatever chattel you want, including your firearm. If you as a private property owner available for public use, if you want to deny access to specific, individuals that are engaged in specific conduct, think of no shirt, no shoes, no service, right? Then you have to specifically exclude them. You have to specifically disinvite them. So, the default rule that she enjoins. Zoos. Apparently, somebody felt it was incredibly important to statutorily prohibit the bringing of a firearm into a New Jersey zoo. She says, no, there's nothing in the historical record to suggest that zoos were sensitive locations. Beaches, playgrounds, and parks. This one gets a little bit, this is where, again, I run into an issue with her. She says that, no, you should be able to carry your firearm on beaches, and she says you should be able to carry your firearm in parks. But then she creates essentially, she doesn't create, she does not enjoin the enforcement of creating a sensitive location with playgrounds. Now, to be candid with you, I don't know the real distinction between a playground and a park, or whether or not playgrounds exist within parks. I think that in and of itself, it might be vague and ambiguous, but in any event, she isn't willing to go to that next step and say that playgrounds are in fact not sensitive locations. Youth sporting events. She says, no, that's also something where the state could theoretically ban the existence of firearms. Public libraries and museums. Apparently, people still like to go to public libraries. Anyways, she says, no, the banning of firearms in public libraries and museums is, there is no historical analog to any sort of legislation or firearms regulation that existed at the time of the ratification. That ain't going to fly. So she essentially enjoins that. Bars and restaurants. She says, no, a statutory prohibition about carrying your firearm into a bar or a restaurant, that is incompatible with the Second Amendment, and she enjoins that enforcement. Same thing with entertainment sites. She said that violates the Second Amendment. Interestingly enough, casinos. And apparently there must be an issue or a fear of people bringing in firearms to casinos. Anyway, she said, no, there were casinos, or at the very least gambling halls, at the time of the ratification, and there was no regulations that prevented people from bringing their firearms or their weapons into casinos. So she enjoins the enforcement of the law prohibiting doing so. Airports and transportation hubs. For this one, she gets really kind of detailed, specifically as it relates to airports. She essentially says, yeah, you can ban the carriage of weapons in an airport, but you cannot ban the carriage of weapons essentially as you're picking up and dropping off people at an airport. So she gets into this really, really kind of detailed fact pattern that she says the state is enjoined from enforcing against someone who just happens to be dropping off or picking somebody up, and they happen to be with their firearm. But she does prohibit the carriage of weapons in airports, all right, and transportation hubs for that matter as well. Healthcare facilities. She says that, if you ban it, that's a violation of the Second Amendment. Public film sets. I know that many of us like to hang out on public film sets. But no, she says that you cannot have legislation that prohibits the carriage of firearms on public film sets. And then a really interesting one that should seem fairly obvious. Chapter 131 attempted to make it illegal, even if you have a concealed weapons permit, make it illegal to be in a vehicle with your firearm. You would have to transport your firearm in the same manner as somebody who doesn't have a CCW. The gun would have to be unloaded in a locked container outside of your control. So essentially, if you had a concealed weapons permit, every time you got into a vehicle, you would have to unholster your gun, unload your gun, store your gun, get into the vehicle, go to your next location, and then rearm yourself up. She says this is pure idiocy and falls completely outside the scope of the Second Amendment, so she enjoins the application of the law against that. Now, there are some exemptions that were written into the Chapter 131. Judges, prosecutors, these legislators, they were exempt from having to deal with any of this nonsense in its entirety. And there was an equal protection challenge that was brought against this particular aspect of this exemption. And like any good judge, she says, oh no, this is perfectly acceptable. Judges and politicians and prosecutors are in a unique position and should be exempted from the law. So she's consistent, I guess, with most other judges that I've dealt with, and it relates to that. She said a prohibition against displaying your firearm in public if you have a concealed weapons permit is perfectly acceptable. And then she goes into some, again, very granular analysis as it relates to specific hunting and fishing restrictions that I won't go into in any great detail. Now, at the beginning of this video, I mentioned that there are sort of national implications associated with this. A lot of states, specifically my own state of California, we are attempting to create gun control legislation antagonistic to Bruin. And, many of these things are being shot down, thank goodness. But this law that New Jersey passed, that this judge has largely enjoined, is very, very similar to the same type of legislation we have in California. And this opinion and her reasoning in this opinion is going to be very, very instructive in ultimately enjoining the same type of legislation that appears here in California, that's going to be appearing in Washington, that's going to be appearing in Illinois, that's going to be appearing in Massachusetts, Hawaii, a number of states, like I said, that are trying to restrict your ability to exercise your Second Amendment rights as much as humanly possible. So kudos to her for, getting us at least farther afield, okay? We'll have to see how the final decision is ultimately ruled on, but at least for the time being, like I said, many of the really, really noxious aspects of this law have in fact been enjoined. As always, if you need to contact me, you can do so at steven@artemishq.com. And again, as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.